Good morning. Today we are going to discuss about the quantum of compensation or the quantum of damages which can be given by the court. Now, the task of assessment of damages will be difficult in personal injuries because money cannot compensate all the personal injuries which have been taken place. As quoted by Lord Morris, he states that if some loss has occurred, some injury has occurred, which has, you can say, physically damaged that person, you cannot compensate him just by giving money and all, isn't it? You cannot renew a physical frame that has been shattered and battered. Once his physical frame has shattered and battered, once his expectation of life are being lowered down, though you give him the money, that will not be the right amount of compensation, you can say. Any amount will be less only. But what here we are going to see, the plaintiff has come in the court, it is for tort, it is for a civil wrong. So he has to ask compensation because that is a basic remedy. At least money can solve few problems, not all problems, but at least few problems the money can solve. But for personal injuries, it is very difficult. So when a tort occurs, injuries can be caused, you can say two types of injuries can be caused. One is property loss which can occur, and the other is the personal loss which I quoted like personal injuries. If there is a tort because of which loss has occurred to property, then what we can do? We can go to the market, check the market value of that property and give the plaintiff the market value. Plus more amount also we can give for filing of a case and all. We can calculate that. Filing of a case, the fees which he has paid, the charges of the typing charges and the other charges, we can calculate it easily. So that can be given to him. Therefore, property loss is not a difficult thing to calculate. The main task of assessment of damages for personal injuries is difficult because money cannot, or money is not an answer for that. However, we have to provide him some compensation. So for property loss, it is easy to calculate. You can compensate the plaintiff in a proper manner by giving him the market value of the property, or you can value the loss which has occurred to his property and you can give him compensation. Whatever loss has occurred, for that compensation can be given. So for property loss, it is very easy, but for personal injuries, it is difficult. And for personal injuries also, we can say that there are two types of loss which can occur for personal injury. The one is non-pecuniary and the other is pecuniary. I'll repeat again. For personal injuries, money is not the answer, but we are going to calculate and give him money. Now for personal injuries, the loss which can occur is either non-pecuniary or pecuniary. Pecuniary loss means what? Which can be easily calculated. I'll repeat again. For personal injury, the money is not an answer, but for pecuniary loss which occurs in personal injuries, you can calculate it. So what will be the pecuniary loss which has occurred? The cost of care, the loss of earning, the consequential expenses. The plaintiff has been assaulted. So what happens? He has been admitted in the hospital. He has to pay the hospital charges and all. We can calculate it. We can check the bill of the hospital and we can give him the money. So this is a pecuniary loss for personal injury. So consequential expenses, money can be given. For cost of care, money can be given. A nurse can be appointed, so she will take some salary, that can be calculated. Loss of earning, because of the injuries caused, he was not able to go to his job for 2 months, 3 months or 1 year also. We can compensate him by his monthly wages. We know his monthly wages. We will calculate it multiplier multiplicand basis, that whatever his monthly wages are multiplied by 12 months is equal to the amount of compensation which should be given for his loss of earning. This is easily calculated. But what is not easily calculated, that is called as non-pecuniary loss. But there also the judge has to apply the prudence of a reasonable person and has to give him compensation. Because of the tort, the pain and the suffering, the mental agony which has been suffered by the plaintiff, that cannot be calculated. But the court is going to calculate some amount, the court is going to give. Loss of amenities which the plaintiff has faced, the amenities he may get or he may not. The court will decide whether to give compensation for those amenities or not, and the court will give it. It is difficult to calculate here, however, it will be calculated. Or the loss of expectation of life. Because of the tort, because of the injuries caused, he has lost interest in the life. The plaintiff was such a positive person. Towards life he was very positive. But because of the defamation or because of the different kind of torts which occurred to him, so what has happened? He has lost his expectation towards life. He has become very negative minded person now. He does not look towards life in that sense. Whether it can be calculated? No, it cannot be calculated. But we have to compensate him. The court is going to give him compensation. Okay. So for personal injuries, it is difficult. Moreover, it is difficult for non-pecuniary loss which occurs in personal injury. But we are going to give him compensation. These are the criteria which the court is going to see while giving compensation to the person. Now, when the first question, the court has to decide whether the defendant is liable. The second question the judge has to decide is about the quantum of compensation, the amount of compensation which should be given. And in that, one more thing is to be done. One more thing the court has to see, that whether the damage which is caused is remote or whether it is direct. So it would be injustice to the defendant also if he is made liable for all the consequences, if he is made liable for remote consequences. Therefore, a person is liable, or you can say responsible in law, only for the consequences which are not remote. That is, only for the consequences which are direct, which are, you can say, natural, which have taken place because of the tort done by the defendant. Therefore, only for the direct loss or only for the natural loss he will be liable, not for remote. For that, one maxim is there called as, or the maxim is, injury non remota causa sed proxima spectator. The plaintiff will get compensation only for that which is a direct consequences, which is a direct loss. The defendant will not be liable for those consequences which are too remote. Now here we have to see whether it is remote or whether it is direct, and therefore two tests are there. One is a direct test and the other is the foreseeability test. Consequences will be too remote if a reasonable man would not have foreseen it. Means whatever has happened, that never a person would have imagined it. So that those consequences will become too remote. He has not foreseen it. As the defendant has not foreseen the consequences which has occurred to the plaintiff, the defendant will not be liable. Means what can be foreseen by an ordinary prudent man, that should have been foreseen by the defendant also, so he will be liable. But the things which cannot be foreseen by an ordinary man can also not be foreseen by the defendant. Therefore, he will not be made liable for those consequences. This is the foreseeability test. The second is the direct test. Defendant is liable for all direct consequences, whether he or the reasonable man would foresee it or not. No, I have not foreseen. The defendant may say like that. But you have not foreseen it, but whatever has happened, that is because of the wrong which you have done. That is a direct consequences. So for the direct consequences, the defendant will be liable. For understanding these two tests, we will see two cases where the facts are little bit similar. The first case occurred in 1921, that is re polemis case, and in this case direct test was applied. A ship was there of the defendant. He he with his servants and all, they are in the ship, and when the ship is coming, what happened? Because of the negligence of the servants, some oil is split and it is on the waters. It is floating on the water nearby the ship, and as the ship goes forward, the oil also, which is inflammable, that also moves further. The ship comes on the port, they throw planks. As the planks are thrown directly in the water, what happens? There are chains, there are iron chains. So ignition is being created, and because of that ignition, fire takes place. That ship is burned and other ships are also burned, and they have filed a case against the defendant because your servants were negligent, and because of that oil and because of that ignition, such a loss has occurred. Court has applied here the direct test, and court has mentioned this is the direct consequences. The oil was there, the planks were thrown, the ignition was created, and fire took place. So this is a direct, whatever has happened, that is because of your wrong, that is a direct consequences. Therefore you are liable for the loss of the people who suffered, or whose ships or whose cargo is being burned. That is a re polymis case which took place in 1921, where direct test was applied. The second case is wagon mount case, which took place in 1961. Same facts: the ship, negligent act, the oil nearby the ship is coming towards the port, but at that time what happens? A tide or the waves, what they do? They take some of the oil far away from the port. They take it, and that oil is now near a creek. After 2 days, means the ship reaches the port, it is there for 2 days. After doing its completion of the work, the ship goes away. After 2 days, some ignition takes place, and the plaintiff's property is like his property or his house or something, or some property is burned. Injuries are caused to him for his property and for himself also. So he files a case, means he searches, he investigates about from where the oil has come and all, and therefore he files a case against that ship, which has gone away now. 2 days afterward this thing has happened. Here the court has applied the forcibility test. What the court has held here, the defendant, while bringing the ship, could never imagine that because of his negligent act, this thing may occur after 2 days. Moreover, not at the port, but it was 200 miles far away from the port. Means the tide is going to come, it will take away the oil far away, and there some injuries are going to occur and all. This cannot be foreseen. So here the defendant was not liable. So in first case, that is in re polymis case, direct test was applied and the defendant was liable. While in wagon mount case, forcibility test was applied and the defendant was not made liable. Okay. Both the tests are very important. The defendant is liable only for the direct consequences, not for those which are not foreseen, not by him, but by an ordinary prudent man. So while fixing the amount of compensation, we have to fix proper amount of compensation so that the plaintiff will feel, and not only the plaintiff, the other people also will feel that okay, proper amount is been given. Justice has been done here. Okay, bye bye. See you in the next video.